Is there a basis, as far as you can see right now in the facts, in current antitrust law to go after these big technology conglomerates?
Well, there are very large companies, but heretofore in our system, it's a system of free enterprise. And if you get to be of a large size because you charge lower prices or you make a better product, then that's terrific. And it would be pretty perverse to have a policy that encourages everyone to run the race of competition only to turn around and immediately penalize the winner. So I think you have to look at each of these companies separately, and there may be particular issues, but I don't think that there's, and there are certain things like scraping of data, the use of people's privacy, the using of pricing algorithms. There's a lot there for antitrust to deal with, but I don't think it's a matter of enforcement, because look what happened. Macon Delraham, the head of the antitrust division, got a lot of what I think was unwarranted criticism for bringing the AT&T Time Warner case. And the Justice Department gave it their all, and they lost in court. So I don't think it's a matter of not enough enforcement.
So, Jen, under the current antitrust law, as it's interpreted by the Supreme Court, being big in and of itself, as Kevin says, is not an evil. At the same time, if you do have monopoly power, if there are bad acts that can be shown either to get that monopoly power or maintain it, then there is a problem. And so are the antitrust authorities, whether FTC or Department of Justice, are they looking at the Facebooks, at the Googles, at the Amazons to see exactly what practices they're implementing?
Well, we know that the FTC actually did look at Google a few years ago. They looked at some of the same practices that Kevin just mentioned and that the EU has looked at, and decided that at least under our framework and under our laws and the precedent that's been built up over the years, they didn't really have a case that they could bring in court against Google. And right now, they're having a series of meetings led by the chairman, Joe Simons, to look at whether or not they have been lax in terms of looking at these companies and looking at the unilateral conduct of these companies, and whether there's something else they should be doing. And in terms of investigations, David, you know, it's possible that one or more of those companies is actually under investigation now. We don't know because these things are confidential.
So that's the law as it now is, Kevin. What about the law as it might become? I mean, Senator Elizabeth Warren is out now with a fairly famous proposal just in the last few days saying we should change the antitrust laws, as I understand the proposal, and say we should require these companies to separate out their basic, I would think, almost common carrier, their overall platform from the ancillary businesses they have related to advertising and things like that. Is that similar to what we've done in the past in some places?
Well, it's similar to divestitures that have occurred in cases years ago. For example, the movie industry, the people that made the films weren't allowed to own the movie theater.
They had to sell them.
They had to sell them. But studies that have been done since then, in particular one by a guy at Brookings, suggested that movie ticket prices actually went up. And it was really the advent of the television that caused competition to come back, because that competed with the movies. So certainly this type of thing has been done. But it seems to me that this is really an assault on our free enterprise system, because it's no-fault monopoly. Under her proposal, if you reach $25 billion in revenues, you've got to split up. So what's going to happen? You get to be a successful $20 billion company because people like your products, people buy them. Look at Apple, and suddenly you'd have to pull your horns so you don't hit the 25 where you've got to break up.
Which is exactly what the courts have said in the past. It just doesn't make sense. At the same time, is it just economic power? Is there also a political power issue here? I mean, we saw this just within the last 24 hours, where Elizabeth Warren had postings up on Facebook advocating her position. Facebook took them down for a time, then put them back up. If you're a politician, you don't like the idea that Facebook could decide whether you can post things or not.
Yes.
Well, yeah, I mean, there certainly is this issue of political power, and there's concern over the power that these companies have over politics or anything else. But the answer to that isn't in breaking up the companies. You know, it's a drastic measure that doesn't comport with where our antitrust laws are today, could harm innovation, and honestly could end up harming consumers in the long run. So if there are concerns about political power or concerns about conduct, you know, any other concerns, those should be addressed directly with, you know, something that can be done to fix that particular issue, rather than just coming in and kind of, you know, taking a hammer to the company.
So, Kevin, that's breaking up a big company now. What about putting companies together? Let's take the flip side of it with T-Mobile Sprint right now, where they're trying to merge. And under traditional antitrust analysis, as I kind of dimly remember it, it would be a tough putt to get that done. You've got the 3 and 4 company in a 4-company market. It's really hard to do. But people are saying, including the people who want to merge, we need to do this for 5G. For the good of the country, as it were. We need to do this. We need the resources to do it. Is that a compelling argument?
if it in fact is true, it's a very compelling argument. I think that it's often not recognized that even if you have very high market shares, and of course this is really more of a 4-3 where there are others with larger market share, but even in a concentrated industry, that if you are able to show that you can achieve efficiencies that are merger specific, that'll get passed on to consumers, that's a defense. And the Supreme Court has never really realized it, but the cases there are older. And so if this is really true and it's going to create something that won't be created without the merger, I think it's a very compelling case, and it's one that's actually anticipated in the merger guidelines that the government uses in making the decision whether to challenge a transaction.
So, Jen, I want to pick up on the efficiencies that Kevin just referred to, because the way the antitrust laws have evolved, efficiencies mean lower prices, basically, particularly to consumers, not exclusively, but to consumers. In this new technology age, is there a perverse reverse effect? Because when Amazon goes into an industry, it lowers prices, and it gets bigger and bigger and bigger, and there's essentially no limit on how big it can get, because it's all deflationary. That's what we're seeing in a lot of technology today.
Well, starting with no limit on how big they can get, right, the way our law is today, as long as they have not getting bigger by doing something illegal, something unlawful, there really isn't a limit. However, you know, the bigger they get, the more they're going to be watched for conduct within the industry that is anti-competitive. But in terms of, I mean, this is exactly the problem with the concept of breaking up these companies, because right now, under our antitrust laws, we look at consumer welfare and we look at the benefits to consumers, and these companies are bringing great benefits to consumers in free products or in lower prices.
So has it always been a matter of consumer benefit, Kevin? I mean, if you go back to the early days of antitrust, didn't this actually get engrafted through the Chicago school sometime back in the 80s?
You're entirely right about this.
Yeah.
And of course, the arguments go on. But for the last 40 years, the Chicago school and the post-Chicago school have held sway. But just one quick point, if I could, to follow up on Jenny. Don't want to go too long on this. But this action that Senator Warren is proposing, who does it benefit? It's not going to benefit the workers. There's going to be many of them who are dislocated as jobs are eliminated. It's not going to help the communities that these workers work in. They're going to be disrupted. Its facilities are closed and moved. And it's not going to help the consumer, because you're going to have to add resources where there had been shared resources. That increases costs, which puts an upward pressure on price. So to me, this proposal it's anti-worker, it's anti-community, and it's also anti-consumer.